How do courts in other European countries, such as Germany and France, balance national sovereignty with the decisions of the European Court of Human Rights? What one gets reading the jurisprudence of the French courts, of the German courts, are, I think, two things. One, and this is a lesson which can be learnt in really general international law in the most general sense too, that is that sovereignty, whether exercised in international relations, in international law, the state acting as an international organ, or in a sense domestically, the parliament, for example, or the organs of the state acting, relying on the sovereignty of the state, when the state binds itself, or when certain constitutional organs bind themselves, what they do is they rely on their ability to do so. So when internationally a state binds itself in a treaty, when it gives its consent to being bound by that treaty, it uses its sovereignty. It chooses freely to be bound. That is what the European states did when they became members of the Council of Europe, of the European Convention on Human Rights. That is what Parliament in this country did when they adopted the Human Rights Act. Parliament, in adopting the Human Rights Act, with an overwhelming majority, made it very clear to the courts of this country that you are to apply this convention. It is to have direct effect within UK law. That is exactly what the German Bundestag did at a much earlier stage than the UK Parliament in the 1950s. The German Parliament made it very clear that within the German constitutional order, the convention is to enjoy a certain rank, and it is to be taken seriously by the courts, and that the courts in Germany have taken very seriously. The same is the case with France, though matters are a little different there because France is a monist country, so you didn't have this act of incorporation into French law of the convention, simply because, in principle, French courts were able to rely directly on the European Convention already from the date when the convention became binding internationally for France. So I think on the whole it's fairly clear that in France and in Germany the courts take their duty very seriously, their duty as expressed by their parliaments to apply the convention loyally, and they've been very assiduous in doing so. What would it mean for human rights in Europe if the European Court no longer had compulsory jurisdiction? It seems to me that the situation you would have then, and this has been very clearly set out by the former Attorney General, Dominic Grieve, QC, you would have human rights protection a la carte. You would end up with a situation, if what we're talking about is the type of parliamentary override that has been foreshadowed in the debates in this country, you would have a situation where only by some process, if a domestic court felt confident, if the domestic authorities of a country felt confident that they would win a particular case, would they allow for the case to go to the European Court, or would they allow for that case to be binding on them? It's a little unclear exactly how this is going to work out, but on the options as they have been presented, it seems that what you would have is something opposite of the rule of law, something opposite of the binding and, in a way, indiscriminate application of law, because law, if it is to have any meaning at all, it must mean, as one great judge of the common law, I think it was Sir Matthew Hale once put it, however high you be, the law is higher than you. The law is taller, rather. So however important a country is, whether it's Russia or the United Kingdom, the idea is that through binding itself internationally to a legal instrument, that legal instrument is, in a sense, taller than you. You too have to bow to that law. And that is what you would go away from. That is what you would remove yourself from in the direction of some sort of willy-nilly a la carte application if one were to have a European human rights court that didn't have compulsory jurisdiction.